Welcome to my channel. Hit like, subscribe, share. Let me know your thoughts in the comment section. First, I would like to let you know that I'm from the academy, and in the academy we overrule the Supreme Court. So don't be surprised if you hear something that runs contrary to what you have believed in. In this video, I'd like to talk about actions taken by Engineer Vitumbiko Mumba, the minister responsible for labor, within the past 7 days or so. As a brief, what has happened so far is that he led the inspection and subsequent closure of a Chinese-owned factory in Irango, which also led to the arrest of a Chinese citizen who I believe is also one of the proprietors of the factory. He also led the inspection of Kawala's tea estate in Kadabe, where violations of basic human rights and labor rights were noted, and it led to issuance of a prohibition notice. He has also been involved in the inspection of Suhana Continental Bakery, Ukukusumba, where, luckily for the proprietors, just few minor violations of occupational safety and health regulations were noted. Now, the minister's actions have led to many commentators voicing out, and key among the issues are as follows. Some are saying that the minister's acts may be deemed as targeting foreign-owned businesses, which may lead to an economic downturn. Others are saying the minister's acts are a ploy aimed at soliciting bribes from factory owners. Others are saying the minister does not have the mandate to carry out the tasks that he has been seen taking recently. Now, obviously, I do not have the competence to talk about the economic implications of the minister's actions. Neither do I have the evidence to talk about whether the minister is soliciting bribes or not. But I can definitely talk about whether the minister has the mandate to engage in those acts and issue those directives or orders. Now, just grab some popcorn, just chill and be there as I delve into this issue. To appreciate the minister's actions, we first need to understand the functions of cabinet minister. In a sovereign state like Malawi, the supreme source of law is the constitution. So what does the constitution of the Republic of Malawi say on duties of the cabinet minister? Firstly, we have section 92, subsection 2, which states as follows. This is the constitution, as you can see. I mean, constitution of the Republic of Malawi. Section 92, subsection 2. The cabinet shall exercise the powers and functions assigned to it by this constitution or an act of parliament, and shall be responsible for advising the president with respect to the policies of the government and with respect to such other matters as may be referred to it by the president. Perhaps crucial to our discussion today is section 93, which specifically provides the functions of a minister, and I'll read it as a whole. Section 93, section 1 says, there shall be ministers and deputy ministers who shall exercise such powers and functions, including the running of government departments, as may be prescribed by the president, subject to this constitution. Section 93, subsection 2 says, every government department shall be under the supervision of a principal secretary, whose office shall be a public office, and who shall be under the direction of a minister or deputy minister. Now, there are some key things to note from this section 93. You will notice that the framers of the constitution and of this section specifically use the word shall. There shall be ministers and deputy ministers who shall be responsible for running the affairs of government departments. There shall be principal secretaries who shall supervise the functions of government departments, and these principal secretaries shall be under the direction of the minister. So what does shall connote? In law, the word shall denotes that something is non-derogable, is mandatory, that you cannot run away from. So from our reading of section 93 of the Constitution, what are the things that a minister cannot run away from? The minister cannot run away from running a government department. A minister cannot run away from directing the actions of a principal secretary in the supervision of a government department. Now let us dissect this further. What does running in relation to governmental affairs mean? An American scholar by the name John D. Michaels, quoted in the Harvard Law Review, that's 128, Harvard Law Review at 1152, states that a government department runs by ensuring that national laws and policies are implemented, operationalized, and adhered to. Now, a minister's role in running a government ministry or department is to ensure that laws and policies are adhered to. In the context of a labor minister, to ensure that laws dealing with labor issues are adhered to. Now, directing, on the other hand, refers to instructions or orders on what to do, when to do, and what to do, and how to do. So in essence, the principal secretary gets orders from a minister when he is supervising a government department. So now let us narrow down to the minister responsible for labor affairs, in this case, Vitumbiko Mumba. The principal pieces of legislation dealing with the Ministry of Labor are the Employment Act, the Labor Relations Act, the Workers' Compensation Act, the Occupational Safety, Health and Welfare Act. Now, what it means is that the Minister of Labor can direct the Principal Secretary or a director responsible for welfare, health, safety and welfare to inspect certain entities to ensure whether, for instance, they are implementing the minimum wage or they are ensuring and adhering to safety measures. What it also means is that the minister can do these things by himself. The creation of specific offices is to ensure that there is ease of follow-up and that things are done smoothly. As one case that I know of states that government is a colossal entity, and that is why you need all these separate and distinct departments and agencies to make sure that it runs smoothly, because the affairs of the government are colossal. And thus posit that the minister has powers of an inspector, even though he is not himself an inspector, but he can do the inspection, because the law that creates the office of the inspector gives him power to direct even the inspector for occupational safety, health and welfare. I posit that the minister cannot give powers to an inspector to inspect when he himself does not have those powers. There is a Latin expression which says that nemo dat quod non habet, which means that one cannot give that which he does not have, or one cannot give that which she does not have. I admit that this phrase or expression is normally used in the realm of property law to say that you cannot give good title if you do not have good title. But I would like to extend it that it may also apply to this scenario by saying that the minister cannot give powers to inspectors when he himself does not have powers to inspect. Let us look at the specific Occupational Safety, Health and Welfare Act, which I have a copy here, just printed. You can freely find it on Google, it's freely available. Just type Occupational Safety, Health and Welfare Act, Malawi PDF, it will give you. This act is aimed at ensuring safety and health and welfare of employees in the workplace. It also provides powers for inspectors to inspect the workplace, to inspect tools and machinery, to ensure that they adhere to certain minimum standards. A reading of the Act shows that the Minister is given the power to operationalize and implement this specific piece of legislation. For instance, Section 12 of the Occupational Safety, Health and Welfare Act provides that the Minister has powers to make regulations to determine the amount of fees or money, let's just say money, the money that can be paid by factory owners or workplace owners for their workplaces to be certified as a workplace. By the way, a workplace has to be registered with the Ministry of Labour. Similarly, under Section 67, subsection 2 and Section 68, subsection 2, the Minister has powers to amend the first schedule to the Act and the second schedule to the Act. More related to the current discussion is Section 67 of the Occupational Health, Safety, Occupational Safety, Health and Welfare Act, which states that the Minister may appoint inspectors, and here's the kicker. The inspectors shall exercise their powers under the general and special direction of the Minister. It means the Minister is above the inspector. As we are about to wind up, it's also important to note that a minister usually travels with a horde of technocrats. So it's possible some of the acts that are being attributed to the minister were actually done by these technocrats. So there may actually be no need to scream that Rome is burning. One may also raise an issue that there are channels of appeal, and the appeal may end also in the hands of the minister who made the decision in the first place. Don't be worried. Under the Occupational Safety, Health and Welfare Act, an appeal does not lie to the minister. It lies to an arbitration board, which is separate from the minister. I'll be doing an injustice if I do not address concerns by some human rights activists to the effect that the minister may be overstepping his mandate. We have already seen that the minister has power to run and direct the affairs of government departments. We have also seen that the direction and running of a government department means engaging in acts to operationalize, to implement and to execute laws and policies that are specific to that ministry. Therefore, I believe the minister is not overstepping any boundaries, but simply doing his job as prescribed by the Constitution of the Republic of Malawi and other laws. Let us escalate this further. We should differentiate the Directorate of Occupational Safety, Health and Welfare, a creature of an Act of Parliament, from other constitutionally created offices like the Directorate of Public Prosecutions. The DPP is said to be under the Ministry of Homeland, but it is an independent office. And the DPP does not answer to the minister responsible for Homeland Affairs. He answers to the legal affairs of Parliament. The DPP may act in concert with the Office of the Attorney General, the Ministry of Justice, and other law enforcement agencies like the Malawi Police Service, the Financial Intelligence Authority, but is not bound by what they may tell him. They may be saved for advice from the Office of the Attorney General, because he's the principal legal advisor for all government departments and agencies. But in terms of operations, the Office of the Directorate of Public Prosecutions is an independent office answerable to the Legal Affairs of Parliament. Legal Affairs Committee of Parliament, as I already said. So there are safeguards that are given to constitutionally created offices and departments like the Office of the Directorate of Public Prosecutions, the Malawi Police Service, the Malawi Human Rights Commission, and the Law Commission, and such other offices, which is not the case with offices or institutions created by Acts of Parliament, which, as we have already seen in the case of the Directorate of Occupational Safety, Health and Welfare, is under the general and special direction of the Minister responsible for Labour Affairs. So we can say that the Minister responsible for Labour, Engineer Vitumbiko Mumba, is not overstepping any boundaries, but just doing his job. Once again, thank you for watching. Click subscribe, like, share, and let me know your thoughts in the comment section. Thank you.